Right now, I think my value add is in deciphering these acts of corruption by Trump, especially from a legal perspective, which we're going to do today on the military deployments. To give you a little bit of the lay of the land, we're going to go through all of them, where the status is on all of them, so you can see what the issues are. Because this is very quickly going to come to the Supreme Court, and we're going to have another standoff at the Supreme Court. One of my big criticisms of the Supreme Court is I feel like they're doing this kind of game of chicken, where they are trying to avoid a conflict with the executive branch, and they're coming to preposterous rulings that don't make any sense, or they're not even giving justification for their ruling. They're just doing everything on the shadow docket as a way to avoid tough questions. That's just an exercise in futility. These questions are going to be arriving. They're in some form. They're going to arrive at the Supreme Court at some point. The court's going to need to make a stand. But yeah, we should not be advocating playing this game where we try to pretend that we're in normal circumstances, and the court shouldn't be engaged in this ultimately futile battle to try to appease Trump. That's what I think they're doing. I think that the Roberts courts will go down in history as one of the worst courts that we've ever seen. And people shouldn't also lionize Amy Coney Barrett. I saw that someone sent me an interview she did or some kind of article. She's been making the rounds. She by far is, I think, my favorite conservative justice on the court. But that's not saying much, right? It's like the least bad person on the court. I think that what she's done is, in many respects, shameful. I think that she's behaving shamefully on the Supreme Court. It's just much less shamefully than other conservative members on the court. I mentioned at the start of this little, I don't know what I'm calling this little monologue, crime has essentially become legal. Look no further than George Santos. I think I briefly mentioned this. Santos is basically hoodwinking, committing fraud on multiple different people, known liar extraordinaire, wire fraud, lying about his religion, lying about his accomplishments, what jobs he's held. He was expelled from Congress because so wide and expansive were his set of deceptions that not even the Republican-controlled House could stomach it. Not even losers like Mike Lawler. I don't believe that Mike Lawler has a principled bone in his body. It's more about how blatant his lies, deception, fraud, corruption was. This is George Santos. That he felt he had to distance himself from the other New York Republicans, the quote-unquote moderate Republicans, all that stuff, right? And Trump commutes the sentence because George Santos is a fan of Trump, and he never talks shit about Trump. This is what you have to ask. If you care, if these people care, they don't care about it, right? If Santos was a critic of Trump, would he have been commuted? No. If Santos was a Democrat, would he have been commuted? No. There's no miscarriage of justice of George Santos's case. This was a purely political pardon. Now, I'm not going to sit here and say the pardon power has never been abused. That's one of the reasons why I try to be consistent on it. It's because once you start to say, corruption doesn't matter when it's my side, well, then you're no better in some respect. Maybe the other side has more corruption. Maybe the other side as an end state wants corruption and you as an end state don't want corruption. So you can find ways to try to distinguish it. But for me, it's just a lot simpler to call out what I think is wrong. I think it's wrong to have corrupt pardons. This is as corrupt as it comes, a pure act of political calculation. Now, why is Trump doing this? Is Trump doing this because he really cares about George Santos? He doesn't give a fuck. He doesn't care about George Santos. And Faith Adams has it exactly right. They're making a point of rewarding loyalty. This is the same reason, by the way, that they dropped the case against Mayor Adams. They're telling you they're not going to go after you if you cut deals with us. Same thing with the universities, with the law firms. You'll be fine. If you do fraud and you're a Trump administration guy or you support Trump, we'll pardon you even if there is one person left at the DOJ in a position to charge these indictments who wants to do it on a neutral basis. Don't worry, we'll pardon you. So what does the incentive send across all the private sector, across the entirety of the country, is don't criticize Trump at all. And that's the opposite, by the way, for Comey, for John Bolton, and for Letitia James and others, which is we'll go after you if you criticize, if you investigate, if you call out our bad acts, you will be targeted. So he doesn't give a fuck about George Santos. He is wanting to send a signal that says, hey, play ball with us, give me a taste, give me a cut, and we're not going to impose the sanction of the state. It is as corrupt as the shit that was happening in Ukraine, as the shit that that happens in Russia, where the government now is not this arbiter enforcing standards in an apolitical, with respect to justice, in an apolitical fashion, or enforcing the law as written in an equal fashion. It is picking and choosing losers based on their willingness to abide, participate in, and cover for government corruption. Same is true of the social media companies who, anywhere where there's a government nexus, where they can extract pain when it comes to mergers and acquisitions, when it comes to FCC broadcast licenses, when it comes to immigration enforcement. when it comes to the use of authority regarding funds for colleges. This is all stuff that's on the table. Every aspect of the federal government has been turned into points of extraction from people, from actors, from private parties, organizations, to give a cut to the Trump dynasty and to give a cut to any affiliated members of the club. That's what has happened. And it's blatant in your face. There's not even any point denying it. The administration itself doesn't really deny it at this point. I mean, they started it in the most ridiculous fashion, accepting this $400 million worth Qatar plane and then signing off on these ridiculous crypto deals and this manifest corruption with Qatar and the Gulf states. So obvious, blatant in your face. And that's why Trump is able to get along with these people, because they all rule in the same way, where the organs of the state are just instruments to enforce the personal wealth and prerogatives of a particular family. And they're talking now about additional changes they want to do to the criminal division of the IRS. Now, tax enforcement is going to be happening from a political basis. That's what all of this like Antifa rhetoric is they're trying to investigate the political organizations affiliated with Democrats by linking them to Antifa. Antifa is this terrorist organization, and we're going to treat them as a foreign terrorist organization domestically. And it's in that context that the deployment of the military in American cities is occurring. So it's in that context, in that miasma of corruption and self-dealing and entrenchment, patterns that we've seen in other countries where you see backsliding on democracy. It's in that context in which the military is being deployed in American cities. And that's what we're going to review principally today. I'm going to show you the current status of the various different cases, where the deployments are happening, how they're being challenged, and how those challenges are faring so far. Taking a step back even further, we already know as a constitutional principle, the framers were concerned with standing armies. You'll notice in the Constitution under Article 1, it provides for the power to raise armies that is time-bound to 2 years. The same time limitation is not present in the Navy. Okay, maybe I'll show this to you so you can see it actually. So here we have under Article 1, Section 8, powers granted to Congress, the power to raise and support armies, but no appropriation of money to that use shall be for a longer term than 2 years, to provide and maintain a navy. So there's a specific fear among the founding generation of standing armies. This is related to other constitutional principles as well. The Third Amendment. You guys ever hear about the Third Amendment? The quartering of troops in homes in the colonies. The Fourth Amendment, the practice of these warrants, these various different general warrants, these warrants, writs of assistance, this kind of stuff, where the military officials and other representatives of the British government were intruding into the lives of the colonists. This is a principle also to be found in the giving to Congress the authority to provide for the militia and for how the militia can be federalized. The president is the commander-in-chief of the militia when it's being federalized, but Congress is in charge of making those determinations as to how, if you don't believe me, to provide for organizing, arming, and disciplining the militia, to provide for calling forth the militia. This is under Article 1, not Article 2. A fear of standing armies, a fear of military governance. They're not trained in the same way that domestic civilian law enforcement is to balance things like constitutional privacy and protections. And this fear of standing armies, this fear of military encroachment into civilian law enforcement, that from that could emerge a destruction of the constitutional order, that is found in numerous different places in the Constitution. These are just a couple of the places that I've talked about. That's sort of a bedrock principle. After the Civil War, you actually do have military governors and military governance of the previous states in rebellion.
The first Reconstruction Act of 1867 replaced state government rule. 5 districts run by Union military commanders were created. These commanders were also charged with registering black men to vote and safeguarding this right.
This is after there was a real rebellion, a real large-scale insurrection, with the participation of state governments in this purported secession. And the military did actually govern aspects of civilian life. So we talked about those bedrock constitutional fears, the different provisions that demonstrate a fear of military encroachment into civilian law enforcement. And then you have the example of the Civil War, in which the military started to take a more prominent role in the enforcement of laws in the South when the state governments began to fail after they lost the Civil War, and there needed to be some sort of temporary governance and military rule. Now, understand the context of that is a massive civil war in which hundreds of thousands of people died, which reordered American society in ways that are explicit in the Constitution with the Reconstruction Amendments. But after that, after the Civil War, and after the practice of these military governorships and military control in the southern states, it's in that context that Congress passed the Posse Comitatus Act. Right? What was Posse Comitatus? It was in response to the enforcement of civil rights law, among other things, in the southern states, and Reconstruction, where the military was taking a prominent role in the enforcement of civilian law in the South. It shouldn't stand to reason from that context that you should always be against the domestic deployment of the military in every single context. That would be absurd. There are some contexts in which it's acceptable and some contexts in which it is not. And we can agree on what those different contexts are. I think what people should agree on is we should follow the law as a bedrock principle, because to the extent that a deployment of the military and keep these concepts separate in your head, federalization, different than deployment, different than particular enforcement actions. Okay, you can think of the federalization of National Guard as a specific action, bringing the National Guard, which has a kind of dual role of both state militia, but can also be called into federal service. That's what this provision of the Constitution, remember Article 1, giving Congress the authority to call forth the militia, to provide those rules, and making the president the commander-in-chief of the federalized National Guards. You can think of federalization as an act of bringing the state militias under federal control. That's one thing. The separate is deploying them, right? Actually deploying them in a particular way or fashion. And then third is like, what are they going to do? And you could take objections to all three of those different things, right? Like how they're federalized, if they're federalized, how and where they're deployed, and what, if anything, they're allowed to do. So just keep those various different ways in which the problem of encroaching military deployments could present itself. And beyond the on paper, because we're going to be going through a couple of these different cases to just give you a lay of the land. I like getting in the weeds, so I can't promise that we won't get a little bit in the weeds. We won't get too in the weeds of each particular case. But taking a bigger step back, even still, is don't let yourself think that this is about the particulars of either the stated issues or what the law says. At a bigger perspective, think of it like a realist. Why is Trump deploying these people here? I gave you the background of all the corruption that's occurring and the weighing of the federal government against private actors. Take a realist position, separate from the formalistic legal stuff we're going to be going over, about why this is even occurring in the first place. This is a case about power. These are cases, I should say, about power. The exercise of military power and political power. It's a sign, it is a declaration, it is a purported assumption of power. And so this is a struggle. What's going on is a struggle right now for power. Who controls these people with guns? What are they allowed to do? What is the president allowed to order these people with guns to do? It's the velociraptor testing at every different point on the electric fence. And the forum is not just the courts. The cities are also the forum in which this conflict regarding power is occurring. It is a battle, metaphorically, as between the states and the federal government, where the federal government is trying to assert supremacy over the state governments with respect to their national guards. Now, there is a supremacy clause of the Constitution, but that presupposes some valid act of Congress or some valid enforcement of a law by Congress and abiding by the laws of Congress with respect to the National Guard and military, which you shouldn't necessarily presuppose here. Whether there's a violation of the Constitution largely depends on whether they're violating Congress's laws. So there's that on the ground, you could say, physical contest. There's this contest between the state governments and the federal government. That's the federalism conflict. That's Newsom versus Trump, right? That's Pritzker versus Trump. That's the state of Illinois versus United States of America. And then there's also the separation of powers conflict. This is Congress and the courts versus the president. Can the court even review it? Can Congress even legislate with respect to this? Did Congress say this or that? So viewed through that lens, that this is a struggle for power. Who is seeking to assert power? It's Trump. Trump is seeking to assert power and his minions. And they're trying to dominate the private individual and push them into fear and silence. They are trying to dominate the state governments. That's how they want these stooges like Eric Adams in charge. That's why we need to have fighters in our state and local governments, not quitters. One of the cases that we're going to talk about is in Tennessee, where the state government is in line with Trump. That's why we need fighters on the local and state level. So he's trying to dominate the private actor. He's trying to dominate the state, and he's trying to dominate the courts, the federal courts, and dominate Congress. So it's an assertion of power, and that's what Trump, this is all about. It doesn't have anything to do with crime. If you're talking crime, you are, I'm sorry to say, a complete victim of propaganda. You're a useful idiot. If you're talking about, well, wouldn't it be useful if we had this or that crime? This ain't about it. This is about Project 2025. Now, I will definitely argue with conservatives who in bad faith try to make this argument about crime. But don't ever think this is about crime. If you do, you're a victim of propaganda. If you do, you're a victim of propaganda. So let's get into some of what's going on here. What is, on paper, Trump doing with these different military deployments? Trump is federalizing National Guard units to the extent that he's not ordering the National Guard. For example, he used Marines in California. There's no need to federalize the Marines. They're already federal. So for those people, it's skipping the whole federalization aspect to it. Okay, kind of similar issues with the DC National Guard, which are typically under the control of the president. Different sets of issues there. But the first thing he's doing is federalizing different components of the National Guard. How is he doing that? He's invoking one of the provisions that Congress enacted to provide for calling forth the militia, right? The militia, from a constitutional perspective, already exists. They owe their allegiance to their various states. That's why Congress is not creating the militias. That's why the Constitution doesn't say Congress shall create the militias. The militias don't owe their existence to the federal Constitution. What is Congress doing? Congress is providing for calling forth the militias, the pre-existing militias. And he can also provide the organization, arming, and disciplining of the militias and governing such part of them as may be employed in the service of the United States, reserving to the states respectively the appointment of officers, etc. So the clear structure, states are going to be in charge of their militias, but Congress can legislate when and how these militiamen, which is what these National Guard people are, how and when they can be called forth. The first of these militia acts were called the Calling Forth Acts. Kind of old-timey language to indicate we're bringing you into the federal service. And so Congress did that, and it's been amended various different times. And the Oval Office occupant, Donald Trump, is citing a particular statute of law to justify the federalization of some of the state militias in this case. When I say state militia here, state National Guard, think similar, okay? This is 10 U.S.C. 12406. This is the law that is at issue in many of these different cases. This law pertains to the federalization of the different components of the National Guard. It says, whenever the United States or any of the commonwealths or possessions is invaded or is in danger of invasion by a foreign nation. Trump has not alleged this as a justification for his federalization of the National Guard. He has cited invasion for purposes of the Alien Enemies Act. That's that old provision of law that allows him to purportedly, right, deport in a summary fashion non-citizens, aliens who are either at war or invading, right, the United States, or a nation that is invading the United States. He has cited invasion for other purposes, other corrupt, I would say, authoritarian maneuvers, most prominently with respect to the Alien Enemies Act. But he did not cite this provision for purposes of federalizing the National Guard. He did cite the other two, sub 2 and sub 3. And this is a lot of what's at issue in these various different cases. And again, I'll give you an overview of the different cases at issue here. 2, when there is a rebellion or a danger of a rebellion against the authority of the government of the United States. Or 3, the president is unable with regular forces. What does this mean, right? To execute the laws of the United States. And it says, if such things exist, right, whenever those things exist, the president may call into federal service members and units of the National Guard of any state, the militia, right, in such numbers as he considers necessary to repel the invasion, suppress the rebellion, or execute those laws. Orders for these purposes shall be issued through the governors of the state, or in the case of the District of Columbia, through the commanding general of the National Guard of the District of Columbia, acknowledging DC's kind of unique role here. So Trump issues a directive to Hegseth. It's like, let's figure this shit out. How do I use the military? There's not really an inciting incident here, folks, right? They're drumming up some bullshit pretext because they just want to use the military, the Department of War, what they're calling it, the so-called Department of War. So what they say in DC, oh, Big Balls was beat up by like a bunch of teenagers. So we're deploying the DC National Guard. Now, at issue in the DC National Guard case, not necessarily the same kind of issues for the state National Guard situations. But just to give you an example, they're not really premising this on specific inciting incidents that we should at least take them honestly on. There's some pretext that they're going to use that is disproportionate to the display of force from a normative perspective. But they were interested to use the Army or the Marines, or I should say the military of the United States in some capacity, and they've been signaling this for a while. This is not the only provision of law that allows for the federalization of National Guard. There's also, famously, the Insurrection Act. So this is not the exclusive method by which National Guard can be federalized, but it is the one that has been cited, okay? Using this authority, Trump has federalized, through Hegseth, parts of the National Guard of California, has federalized parts of the National Guard of Illinois, two states that are run overwhelmingly by Democrats, federalized parts of the National Guard of Oregon, another Democratic state, has done so in DC, contrary to the wishes of the DC officials. And then, interestingly, in Tennessee, he is relying on the governor there and the state authorities, not the local authorities who are against it, but the state authorities who are supporting him. There, I don't think that they federalize the National Guard, but they are working in conjunction with the Tennessee state authorities to deploy. Okay? So that's a big picture. 5 different places. California, mostly LA, but it's spreading. Illinois, Chicago, Oregon, Portland, DC, Memphis. Got it? So the different cases, likewise, follow those different states. The main case in California is in the Northern District of California. The judge there is Judge Breyer. That gets appealed at the trial level to the Ninth Circuit Court of Appeals. There's a case in Oregon, a federal case in Oregon, that also gets appealed to the Ninth Circuit. The case in Illinois gets appealed to the Seventh Circuit Court of Appeals. Case in DC hasn't yet reached the DC Court of Appeals, but will if it goes there. The Tennessee case is a state case. It's occurring in state court. Why is it occurring in state court? Well, it's occurring in state court because they haven't been federalized, right? And so maybe there's a federal issue, but the petitioners there, which are basically leaders of Shelby County, I think, which is where Memphis is, are suing the Tennessee officials there. So it's a little different of a posture, okay? I previewed at the start of this that you can attack various different aspects as the plaintiffs of what the government is doing here. One, you could charge the defendants and say, hey, you're not allowed to federalize either because you haven't met one of these substantive preconditions, right? Precondition 2, precondition 3, precondition 1. So you're not even allowed to federalize, right? You could make that kind of challenge. Or from a procedural ground, you could say, hey, maybe you could federalize, but in order to do it, you need to do it the right way through the governors of the states and not directly, right? So that's one thing you could do, is challenge the federalization either substantively to say, hey, you haven't met one of the preconditions here, or procedurally this is bad. You could challenge the deployment, say, all right, you're allowed to federalize, but you can't deploy right here because of X, Y, or Z. And those could relate to substantive provisions of this statute, or it could relate to procedural stuff, or it could relate to other constitutional issues. Or you could challenge what they're doing. There's another law called Posse Comitatus that I talked about, which prevents the military in general from enforcing civilian law. Just like the standard for the National Guard is that the states are the ones who enforce aspects related to their militias. The standard is that the military doesn't enforce civilian law. But just like there are exceptions to that National Guard militia stuff where Congress can call forth the militia, there are exceptions to Posse Comitatus. Posse Comitatus, which says that the in general military doesn't enforce civilian law, actually makes it a crime for the military to enforce civilian law. But there are exceptions to that provisions of law can provide for the military enforcing laws in some cases. So big picture, you can challenge their federalization, you can challenge their deployment, you could challenge what they're doing. Are they enforcing civilian law or are they not enforcing civilian law? Additionally, in sort of other ways, you could say in particular cases, what the National Guard or ICE is doing is unconstitutional because it violates rights. That's kind of a different theory, right? One is like a power question. You don't have the power to deploy like this. You don't have the power to enforce civilian law. You don't have the power to call forth the militia. You don't have the power to deploy. Another aspect is more of a rights question as opposed to a power question. You can't, what you're doing right here is infringing on our rights, separate from Posse Comitatus, separate from the substantive provisions of the Calling Forth Acts and the Militia Acts. Is what you're doing violating individual rights of citizens, non-citizens, etc., in the various different places in which you're deploying? So that's a hodgepodge of stuff, complaints that plaintiffs can bring against the government and what they're doing. Some of these, I think all of these have been raised in the various different cases, as we'll see. Some responses from the federal government, from Trump specifically, could be like the following. A, we do have the authority, we have the power because one of these conditions is met, right? Or, we followed all the procedural stuff. Or we're not violating rights and you haven't made out your case. So the government could respond by negating the arguments of the plaintiffs and saying, actually, we are authorized to do this, and actually, we're not violating the rights. They could also take a different view and just say, whether we are or not allowed to do this, whether we're allowed to call forth a militia, whether we're allowed to violate rights if we are violating the rights, you, court, can't hear this challenge. The court doesn't have the power to adjudicate this matter, either because Congress said that you can't do it, or because we have an inherent discretion to do anything we want, or for some other reason that these cases are unreviewable. So the posture of the defense here, the government, can be either A, we are authorized to do this, we're allowed to violate your rights, or we're not actually violating your rights, or we actually do have the power to call forth a militia in this context. We have the power to enforce civilian law here, or we're not enforcing civilian law. And additionally, there can be some kind of like even bigger, broader question of, does the court even have the authority to hear this case? And they deploy this shit all over the place. They did it in the CASA decision, in the kind of the case regarding whether or not universal injunctions are allowed under the Judiciary Act of 1789. They raised this in numerous different places, and most famously in Trump v. United States, when they said that Trump has immunity. Right? Former presidents have immunity, criminal immunity. And so basically Congress can't either, you can view it as Congress can't legislate, or the courts can't render decisions that intrude upon the core prerogatives, core powers of presidents. So those are the kind of different concepts that are at play in various of these different cases. So let me give you the kind of status of all of them. So in the Ninth Circuit, you initially had Judge Breyer in the Northern District of California say, hey, you're not authorized procedurally or substantively to federalize the National Guard. That was his initial ruling, and said, we're not deciding on Posse Comitatus. A reminder, that's whether the military, right? One thing is federalizing them and deploying them. The other is like, are they allowed to do what they're doing? Judge Breyer there said, I'm not going to touch Posse Comitatus, but at a bare minimum, you're not allowed to procedurally or substantively federalize the National Guard in the way that you did for the reason that you did. That was the initial decision by the Northern District of California. And in case you're wondering, that's this case. Just go to Court Listener. You can find it. You can find when it was filed. It's Charles Breyer. This is Justice Breyer's brother. And you can go through all the different motions if you want. The initial decision was you can't federalize. Then Trump appealed, and Trump asked for a stay by the Ninth Circuit on this ruling. Remember, the ruling didn't touch Posse Comitatus. And the Ninth Circuit granted it. This is a case I really disagree with. And I'll tell you why in a second, and what Judge Breyer did in response to it, and why it's such a disastrously ruled decision by the Ninth Circuit. But the Ninth Circuit gave a stay to the government on the lower court order and said, basically, this is why. And I'll tell you why. The Ninth Circuit found that these kinds of things, these kinds of federalizations, they are reviewable. They are reviewable by the courts, but you got to give a shit ton of deference to the executive branch, and you're basically just inquiring into whether or not they issued the decision in good faith. So whatever the standard is, it's highly deferential to the findings of the president. That the procedural stuff, they didn't buy the procedural argument either, but that basically for 1, 2, or 3, the Ninth Circuit said, you got to give maximal deference to the president for any of these different findings, okay? And I can show you a little bit of that opinion. First was the question of whether they had actual appellate jurisdiction over the TRO that was issued in the lower district court in California. They decided they did. Their conclusions of law. They didn't decide on Posse Comitatus, which Breyer later decided on. That's the one I most wanted to get you guys to look at. But this is what they said. They said that we disagree with Trump that it's not justiciable, okay? That this is very much justiciable by the courts, that we're allowed to look into this. And They said, however, to what extent does Trump's discretion, even if we do review, to what extent do we have to listen to what the president says? And they're like interpreting the statute as to how much deference to give the president. Trump says that it precludes review what the statute gives, and they're like, this is not true. It doesn't preclude review. How much deference do we give? Again, right? And the Ninth Circuit says that this is a question of statutory interpretation, right? Congress could make it whatever they want. And look at what they say here. If we were considering the text of it alone, we would conclude that the president's determination is subject to review like certain other factual findings that are preconditions for executive actions under a statute. So like normally, if we were just looking at this law by itself, we would say that there's not like any additional weight that we give to the president's determination. Okay. That's what the court is saying here. If we were considering the text of it alone, 12406, but we are not writing on a blank slate. We are deciding in context of Martin v. Mott. Now, this is the main case that is cited by Trump, where in the this was after the War of 1812. There was a militia guy who like refused to get called up. And so the government tried to fine him for, they tried to fine this Mott guy, right? Like Mott said, I'm not coming up. And then later Martin, who was whoever, the prosecutor or whatever, was like, hey, Mott, you have to pay a fine and you have to, do this shit. In this case, the court had some kind of loose language, which is basically like this is back in the 1820s. The president's decision here is unreviewable when he makes those decisions on preconditions. And so the court is saying, if we were interpreting the statute, we wouldn't interpret it, but Congress was writing in the context of Martin v. Mott. Now, I think there are a lot of problems with that, and Judge Breyer will call something out. But this is why they're interpreting this to give the president a lot of deference, is because, like in Martin v. Mott, when President Madison called forth the New York militia, this is the Militia Act of 1795, but it was President Madison in the War of 1812. Jacob Mott said, no, I'm not coming. Mott then brought an action for a replevin, a writ of replevin.
We'll come after you with a writ of replevin.
A what?
Writ of
All
replevin.
right, now
Because he was court-martialed and fined. So the state seized his property, and then this guy, Jacob Mott, he comes to the court, to a state court, and says, give me replevin. I want to seize the stuff that was seized from me. Go grab it, court. That's what a writ of replevin is. He sought an action for replevin. So Mott sues the state who seized his property. He says President Madison's order federalizing the militia was invalid. That's what Mott says. And Supreme Court said the president is the sole and exclusive judge on whether the exigency has arisen. That's where Trump is getting this whole thing of like, you can't question the president's decision. Now, this is a precursor statute, the Militia Act of 1795. It's not the current statute. But basically, the court is saying that we should follow what Martin v. Mott is. Plaintiff correct. This is the part where I think that Martin v. Mott has been brought into a lot of dubious questions, and where the Seventh Circuit diverges, and where I'm going to give you like the current status of the case, because there's a bunch of interesting stuff that comes off of that. Plaintiffs correctly note that some of the Martin's court's reasoning address factual circumstances that are not present here. So there are a lot of factual distinctions that dealt with an invasion from Britain, right? But that doesn't really change the interpretation of the statute, is what the Ninth Circuit here is saying. This is a panel of 3 judges on the Ninth Circuit, okay? That view of Martin v. Mott has remained the settled understanding of the Supreme Court and among legal scholars. Press X to doubt. Fourth, we recognize that Martin concerned a question that directly implicated foreign policy, and they're basically saying the factual circumstances here don't matter. It's a matter of statutory interpretation. California emphasizes that Martin is nearly 200 years old and that it is in some tension with more recent decisions about the reviewability of executive determinations, especially like the Alien Enemies Act. So the Supreme Court recently said that the courts can review as to whether there is a precondition for the Alien Enemies Act. So that's what we mean by this inherent like tension. You have Mott that stands for the proposition that you can't question the president's determination as to preconditions like invasion, etc. And then you have the Alien Enemies Act cases, which are like, wait, the courts are allowed to question whether something is an invasion for purposes of alien enemies, but not for militia. That's what California is calling out. It's like, even if you read Mott at its broadest, which was dealing with a different statute, it's not been squared with the recent case law, as recent as like this year, on the Alien Enemies Act, and the courts are able to determine the same kinds of stuff as and so this is where what the Ninth Circuit is kind of signaling here is that maybe we would decide Martin v. Mott differently, but we're not allowed to. Look at this. But Martin's continuing viability is not for us to decide. The Supreme Court has admonished that if a precedent of this court has direct application in a case, yet appears to rest on reasons rejected in some other lines of decisions, the Court of Appeals should follow the case which directly controls, leaving to this court the prerogative of overruling its own decisions. So the Ninth Circuit here, I think, is highly, highly suggesting that they would have done it differently if they were allowed to like overrule Martin v. Mott. and suggesting that you would need to overrule Martin v. Mott in order to get to a different conclusion. I don't necessarily agree with the latter, that you would need to overturn Martin v. Mott to come to this determination. Martin v. Mott is a statutory interpretation question, not a constitutional one. Ninth Circuit continues, and we'll talk a little bit about the ramifications of this standard of review, which basically gives a lot of deference to the president. This is the Ninth Circuit. All that said, Martin does not compel us to accept the federal government's position that the president could federalize the National Guard based on no evidence whatsoever, and that courts would be unable to review a decision that was obviously absurd or made in bad faith. So the first thing to note is this is totally insane, right? How can you say Martin v. Mott governs? Remember what Martin v. Mott said, sole and exclusive judge, right? Sole and exclusive judge. If you're going to bite the bullet that Martin v. Mott governs, sole, exclusive, president, why does the court get to step in and like basically get into the weeds on whether something was absurd or made in bad faith? Surely the president who is the sole and exclusive, right? Sole and exclusive determiner of the preconditions, it's his determination that is whether something is absurd or bad faith. So I think that the Ninth Circuit in the Newsom case is being inherently contradictory. If you accept Martin v. Mott, it's not up to the courts to determine whether or not something is absurd or done in bad faith. Where is the ability for the courts to review something that's in the sole and exclusive prerogative of the president? So this is one of the, I think, inherent contradictions in this case, one of the reasons I hate it. Now, as a practical matter, I'm glad that they're not foreclosing all forms of judicial review of this case, but the way they're getting there is not analytically rigorous. This is another example of the kind of shit that the Supreme Court does. This doesn't make any sense. They're trying to have their cake and eat it too. If you want to have your cake and say Martin v. Mott clearly holds, and we need to hold Martin v. Mott even though it was a different statute, even though I think the language there is incredibly loose, and we should understand Martin v. Mott in the context that it occurred. I'll show you in a second the Seventh Circuit opinion, which is typically thought of as a less liberal circuit, I should let you know. There are two Trump appointed judges on this Ninth Circuit panel and one Biden appointed judge on this panel, but it was a unanimous decision by this panel. The Ninth Circuit, it's only 3 judges. But this is the kind of shit that bothers me because it doesn't make sense. If you're going to go with Martin v. Mott says exclusive, sole, president. It doesn't leave open areas for the court to like review, right? Whether something is absurd or done in bad faith. If you interpret Martin v. Mott in the way that the Trump administration is wanting us to interpret, in the way apparently, right, that the court in the Ninth Circuit is trying to interpret it. What they're trying to do is like say, okay, we can review some things, but Trump wins this case. We're gonna give him this win. Now it was temporary, and it was later. I'll tell you what happened and what changed and why it might still change. In Martin, the court addressed the argument that the power confided to the president is a limited power, can be exercised only in the cases pointed out in the statute. And the court explained that when the president exercises an authority confided to him, the presumption is that it is exercised in pursuance of law. As the court noted, a public officer is presumed to act in obedience to his duty until the contrary is shown. Moreover, discussing Martin, the Supreme Court has observed that the nature of power also necessarily implies that there is a permitted range of honest judgment. So they're basically hodgepodging together different statements. Again, the presumption, this is a presumption that Congress had. This presumption wasn't for the courts to question if you take Trump at his word, and as the Ninth Circuit is suggesting there, they're basically coming up and stitching together some different language from different cases, and even in Martin v. Mott, some language that seems to suggest, that there's a presumption that they're going to be honest and stuff, and therefore we can get into whether it's honest. Consistent with Martin, courts may at least review the president's determination to ensure that it reflects a colorable assessment of the facts and law within a range of honest judgment. So now, instead of it being sole and exclusive, the president's discretion as to whether there's precondition, sole and exclusive, except every single court in the United States can question whether or not there's a colorable assessment of the facts and law within an honest range of judgment. That's what I mean. Like, it's totally unjustifiable to take the Ninth Circuit panel's view here that Martin v. Mott is giving this enormous amount of deference, but it's leaving open some judicial review. So if things get really, really bad, maybe we can step. But things are getting really, really bad. They are really, really bad. And this is not honest. This is the decision of the panel. Now, I'll let you know that there's a current pending motion as to whether the entire case should be reconsidered in bank. In bank meaning by the entire Ninth Circuit. So this is a panel of 3, and there's a pending motion about whether it should be heard in bank. And this is from July 11th. A judge of this court has called for a vote to determine whether this case should be reheard in bank. The parties are directed to file simultaneous briefs setting forth their respective positions on whether this case should be reheard in bank. This panel, we need to rehear this. And so right now there's a pending motion still as to whether the entire Ninth Circuit should reconsider the case. And that was initiated by a judge of the Ninth Circuit. So that's one indication that I think this is shaky. Another reason why I think it's shaky is what the court had to say about inability to execute the law. So the first aspect that I just talked to you about is like, what level of deference do we give the president on any of these preconditions? Separate from that, it's understanding what these provisions even mean. This, the court is allowed to interpret fully, right? What these words mean. And how the Ninth Circuit interpreted inability to execute the laws of the United States, they only meant, when they wrote this, not total inability to enforce the laws, but like a significant impairment of the law. So two things, right? So the first is, we give the president a shit ton of deference per Martin v. Mott, although not the sole and exclusive. And for subsection 3, inability to execute the laws of the United States doesn't mean inability to execute the laws of the United States. It just means some significant impairment. And that's what the Ninth Circuit said in coming to a determination about what these words mean. Okay? How does that relate to why, is this precedent even viable as it stands right now? How it interacts with Posse Comitatus is unsupportable, is totally unsupportable. And Judge Breyer points that out in the following and latest update on this case. Because remember, the Ninth Circuit wasn't judging whether or not they violated Posse Comitatus. They were just dealing with these threshold power questions, and they offered a stay of the judgment as to the power questions. Separately, there's this Posse Comitatus issue, which is, regardless of whether they can federalize the California National Guard, is the California National Guard allowed to enforce civilian law? And that was still open for this for Breyer to go on. And so he actually had a trial. Breyer had a trial on Posse Comitatus. They introduced a bunch of evidence. And so separate from the calling forth stuff, they like introduce evidence like, are you violating the Posse Comitatus? Are you enforcing civilian law? Is the military doing this in a way that's illegal? And Judge Breyer found that they were, right? So the Ninth Circuit stayed on the calling forth aspects of the case, on the federalization aspects of the case, in a totally absurd ruling that I disagree with wholly, that I hope the Ninth Circuit reviews en banc. But the Ninth Circuit left open Posse Comitatus. So the Northern District of California, Breyer had a trial on Posse Comitatus, okay? And found that regardless of what you have to say about federalization, the Marines and the National Guard are violating Posse Comitatus by enforcing civilian law in California. So that's like the latest on. So even if you buy some of the narratives, which are like, so the Ninth Circuit shot it down, it's still in litigation. It's still being appealed. It might be reviewed in bank. And the Ninth Circuit hasn't addressed the Posse Comitatus issue, which they found that it violated Posse Comitatus. In coming to the decision on Posse Comitatus, this is what Breyer said. And I don't understand how it's possible for the Ninth Circuit to get around this argument. It's a Posse Comitatus argument that bears on 10 U.S.C. 12406. And I'll tell you how. It's absolutely, I think, just a rock solid argument. And in so many words, Breyer eviscerates the Ninth Circuit position and shows that he doesn't agree with it. 10 U.S.C. 12406. They dealt with standing separately. These are conclusions of law. So I'm skipping a bunch of legal analysis. I just want to get to the point that I want to get to you. One more preliminary question remains before addressing whether defendants have violated Posse Comitatus. Recall that President Trump federalized the National Guard under 10 U.S.C. 12406 sub 3. That's this sub 3, right? Inability to enforce the laws of the United States. Remember what the Ninth Circuit said. Ninth Circuit said some significant imposition, and Breyer will get into it, which provides that the president can do so whenever, right? Federalizing, whenever the president is unable to, with the regular forces, execute the laws of the United States. Defendants argue that 12406 sub 3 is an exception to Posse Comitatus. So the act does not even apply to the federalized National Guard. The court now addresses that contention. So what Trump is saying is, we don't need to follow Posse Comitatus if we federalize under sub 3. That under sub 3, it presupposes enforcement of civilian law. To start, the court is unaware of any person, government lawyer, military, civilian official, court, or commentator, who has made this argument other than defendant's lawyer in this case. The Department of Defense, Department of War now, right, has not taken this position in its publications on the Posse Comitatus Act. So Trump is offering a novel argument here. Novel argument, which is this 12406 sub 3 is not only an exception to calling forth the militia, which is typically under state control, but it's also works as an exception to Posse Comitatus. As Mr. Harrington, one of the witnesses, put it, everyone knew that Posse Comitatus applied. So even this is basically the court saying, you guys don't actually believe this. You were acting as though Posse Comitatus applied. So this is a purely litigation argument that you didn't actually hold to during the deployment. Defendants, however, advocate for this novel reading of 12406 sub 3 and Posse Comitatus that would represent a marked shift in the balance of powers between the executive and the legislature. The impact of the defendant's argument is largely due to the Ninth Circuit's reading of 12406 sub 3 in its order staying this court's TRO pending appeal. So he's taking a shot. This is Breyer taking a shot at the Ninth Circuit. And you'll see why, because it makes total and complete sense what Breyer is saying after this. And I'm floored that the Ninth Circuit could have come to such a ridiculous decision on 12406 sub 3. In that order, the Ninth Circuit held that the court can review the president's invocation of 12406 only to determine if, one, it has a colorable basis, and if it's made in good faith, sub 11. This standard purportedly comes from the Supreme Court's decision in Sterling versus Constantine. So again, Breyer is taking shots at the Ninth Circuit and what it said here. As in, he's skeptical, that's why he has purportedly, and I'm skeptical as well, that this standard comes from anywhere whatsoever. The Ninth Circuit did not clarify these standards further. For example, it did not explain how a plaintiff could challenge or how a district court could evaluate, especially on an expedited basis in proceedings for preliminary injunctive relief, a presidential invocation of 12406 for a lack of colorable basis or good faith. Like, he's again taking another shot at the Ninth Circuit saying, I don't know, how would you possibly evaluate this during like the injunction phase? You're basically making it impossible for us to give relief in cases in which there's no colorable basis or good faith. It's like, it's not really a workable standard that courts can actually deploy. It'll just result in the government always winning all the time. Nor does the Ninth Circuit suggest that courts are well positioned to evaluate whether the president acted in good faith. Another issue, right? Like, supposedly if courts aren't in a good position to evaluate the facts of the ground with respect to the National Guard and with respect to invasion and all this other stuff, how are courts in a good position to evaluate the president acting in good faith? Another reason why the Ninth Circuit's reading is completely preposterous to the extent that it's based on this Martin versus Mott precedent, rather than as a pretext for federalizing the National Guard. Like, how are courts well positioned to do this kind of conclusion if you don't think they're well positioned for the other? The Ninth Circuit also suggested the president can invoke 12406 sub 3 if his ability to execute federal laws has been, quote, significantly impeded, rather than the stricter statutory requirement that he's unable with the regular force to execute the laws. So here he's contrasting what the Ninth Circuit suggested and what the statute actually says. So another shot at the Ninth Circuit panel. Again, there's a good reason why I think this should be heard on a rehearing in bank. Thus, under the Ninth Circuit's test, the president could federalize the National Guard in any number of cases. Look at these like insane hypotheticals that this would open up for, and then look at the history of Posse Comitatus and see if it makes sense. Because remember, the Ninth Circuit said inability to execute the laws means significant impeding, right? Significant impeding. The president, relying upon IRS data, showed that a sizable percentage of corporations and individuals are using tax shelters to avoid paying taxes, could claim that he is unable to execute the tax laws, right? You just say there's a significant imposition, a bunch of corporations and individuals aren't paying taxes, so we can deploy the military. That would be good under the Ninth Circuit test. The president, relying upon EPA studies showing that pollution in a river cannot definitively be traced back to a specific manufacturing plant, could claim that he is unable to execute the Clean Water Act, so deploy the National Guard. The president, relying upon health data showing the number of individuals who present to hospitals with narcotic-related symptoms, could claim that he is unable to execute the federal drug laws, right? A lot of drug abusers, and I'm unable because I'm significantly impeded in enforcing the drug laws because we have a bunch of people who are showing up to hospitals who are drugged out, so we should have the military deployed to enforce the law perfectly and take over hospitals. The president, relying upon anecdotes from state election officials that voting machines are glitching or that fraud exists, could claim that he's unable to execute the election laws and therefore deploy the military, right? And this one is striking. Why does he end there, right? This is exactly what he's suggested he wanted to do in 2020. So this is what the argument from the Ninth Circuit, by interpreting inability to enforce the law, just meaning significantly impeding, that it would justify all manner of insane hypotheticals. Now look at the history. In each instance above, the president would have asserted a colorable good faith claim. Under the Ninth Circuit test, that is all he would need to do in order to call the National Guard. And then under defendant's urged interpretation, use these troops to execute the domestic law, right? Use the National Guard, use the military to enforce election law because someone said that the machines are glitching. I'm significantly impeded from enforcing election law, so I have the military run it. Though defendants initially did not disclose the implications of reading this as a grant of significant presidential discretion, they have now fully fleshed out their views. In doing so, they make plain the consequences of the Ninth Circuit's highly deferential reading of that statute. Another shot at the Ninth Circuit. This is remarkable from the lower federal judge here, but it just automatically follows. I mean, what is the argument that these things like wouldn't follow? That you couldn't mobilize the military to, instead of inability to execute the laws, it's significant imposition, and that only needs to be based on a good faith and colorable claim by the president. So, okay, then basically all of this stuff becomes justifiable under the law if you adopt the Ninth Circuit's insane test. It is unclear from defendants' briefs and oral arguments whether they believe 12406 sub 3 allows federal National Guard troops to execute any laws or just those that the president found he could not enforce under 12406 sub 3. The former interpretation is certainly extreme. Could the president, for instance, assert that he's unable to enforce obscure obscure tax or drug laws and then use the federalized National Guard to execute the election laws. But the latter interpretation is equally flawed. Consider the context in which Congress passed the Posse Comitatus Act. There is little question that without the support of federal troops in southern states, the voting laws that enfranchised newly freed black men would not be enforced. So in defendant's view, the federal government would have been authorized to invoke the predecessor statute of 12406 and circumvent the Posse Comitatus Act. This reading would have rendered Posse Comitatus effectively useless at the time it was passed. Understand, this is the killer argument, right? The whole reason was to limit the military encroachment into the state affairs, right? That's the whole purpose for why Posse Comitatus was passed in the first place. So if you interpret, because the predecessor statute is similar, if you interpret this significant imposition test instead of the words, which are inability with the regular forces to execute the laws, then basically you're saying that Posse Comitatus means nothing, because under that reading, it would have been an exception to Posse Comitatus, and obviously the South had a significant imposition on the election laws and the Equal Protection Clause after the Civil War, and so military can just continue as it was, right? Under 12406 sub 3 or under the predecessor statute. So like that is the killer argument, which is they didn't pass Posse Comitatus to not actually restrict what the government's allowed to do. They passed it to restrict the military enforcement of civilian law in the context of Reconstruction. And if they passed a law to limit military enforcement of civilian law in Reconstruction, it must have actually limited it. Okay? And it wouldn't make sense to make an exception that's so big to Posse Comitatus that it would render Posse Comitatus like totally disregardable. Because you could just say, oh, I'm just gonna have the military do it because there's a significant imposition to the election law in the South. Why would they pass Posse Comitatus? It makes no sense. That's the killer argument. And the Ninth Circuit, there's no good response to that. There's absolutely no good response to that. Of course they didn't pass Posse Comitatus to be dead letter. This was part of their deal. To end Reconstruction. Now you can have problems with how Reconstruction was ended, but as a matter of statutory interpretation, no one thought that Posse Comitatus was just like not doing anything, that they could just be ignored. Why go through all the effort to pass it, to just ignore it? Citing Scalia, right? Scalia for saying the presumption against ineffectiveness ensures that a text's manifest purpose is furthered, not hindered. Congress presumably does not enact useless laws. Relatedly, Congress does not hide elephants in mouse holes. The court will not take the defendant's invitation to create a brand new exception to the Posse Comitatus Act that nullifies the act itself, right? If it's so trivially avoided, it's so trivial to avoid Posse Comitatus, you just say, oh, significant imposition, use the military to enforce the law. Moreover, a close look at the recognized statutory exceptions to Posse Comitatus counsels against rather than in favor of defendants' positions. Many of these statutes only apply in very specific circumstances. Like, look at all these specific laws that authorize the military to do certain things, right? To prevent trespassers on national parks, to remove people on native lands, to do military quarantines, right? The fact that we have all of these specific grants of authority for the military to do certain things counsels against us interpreting this subsection of a provision to create a gaping hole in Posse Comitatus. Look at all these different minute exceptions that we have to Posse Comitatus. These are narrow exceptions. Unlike defendant's proposed exception, they do not undermine the whole act, nor does the Insurrection Act. To be sure, the Insurrection Act is a recognized exception to Posse Comitatus. Yet the Insurrection Act, which provides 3 avenues to deploy the National Guard, imposes meaningful guardrails on the president's authority. The president can invoke the Insurrection Act only if the state legislature or governor requests it. So you can invoke the Insurrection Act if it's requested. 2, if he determines that unlawful obstructions, combinations, or assemblages or rebellion make it impracticable to enforce the laws in any state by the ordinary course of judicial proceedings. Or 3, he determines that any insurrection, domestic violence, unlawful combination, or conspiracy so hinders the execution of the laws of the state and of the United States within the state that any part or class of its people is deprived of a right, privilege, immunity, or protection named in the Constitution and secured by law, and that the constituted authorities of that state are unable or refuse to protect that right. So look at how Breyer puts it, which I think I totally agree. Under the Insurrection Act, then, the president's authority is restricted in some way, either by a request by a state legislature or governor, a finding of the courts, or by the inability or unwillingness of local officials to act. In other words, the Insurrection Act sets as a default presumption that state and local officers will be able and willing to protect a right, privilege, or immunity secured to the people. But Trump did not rely on the Insurrection Act. Defendants disclaimed reliance on the Insurrection Act at trial, right? The trial for Posse Comitatus. And this is perhaps a tacit admission that President Trump would be unable to make the showing required under the Insurrection Act to rebut the presumption that state and local officials in Los Angeles were unable or unwilling to act. Of course, neither the California legislature nor Newsom requested troops. There's no court order to enforce, so these provisions of the Insurrection Act do not apply. The Ninth Circuit's interpretation of 12406 sub 3 provides no similar limiting principle, while a straightforward reading of 12406 sub 3, so this, again, another shot at the Ninth Circuit, that is, the Ninth Circuit's interpretation is not straightforward, which references the regular forces might suggest that it would apply only if civilian officials are unable or unwilling to execute the federal law, the Ninth Circuit indicated that it would not adopt such a view. The Ninth Circuit's expansive view of presidential discretion to invoke 12406 sub 3 affects the viability of defendants' argument that the statute operates as an exception to Posse Comitatus. Their argument, when combined with the Ninth Circuit's reading of 12406 sub 3, would create a loophole in the Posse Comitatus Act that would swallow the entire act, and the Insurrection Act along with it, as 12406 sub 3 would place no meaningful guardrails on the federalization and use of National Guard troops and would thereby render the Insurrection Act redundant, right? Understand what that means, right? We have all these different specific provisions of law that allow you to do an exception to Posse Comitatus, but if you accept the Ninth Circuit's framing, if all you need is a significant imposition, right? You don't even need an insurrection. You don't need a rebellion. You don't need inability by the state. You don't need a specific narrow circumstance like the Department of Health is doing a quarantine. You don't need a circumstance like the National Park. Then why write the Insurrection Act? Why write all this other stuff? The court therefore concludes that 12406 sub 3 is not an exception to Posse Comitatus. If the president wants to avoid the act's restrictions, he must invoke a valid exception like the Insurrection Act, along with its requisite showing that state and local law enforcement are unable or unwilling to act. So this, in my opinion, is the absolute slam dunk argument against the Ninth Circuit's position on 12406 sub 3, and frankly, also on their deferential standard that they're applying here. That if you accept what the Ninth Circuit says, then all of this shit doesn't matter because it's so broad and so discretionary that it's pointless to even argue. And the president can just trivially enforce any federal law with the troops at any time. And so that's why I'm urging to the extent that I matter, the Ninth Circuit to rehear this in bank. Now that they've made their argument clear, Trump has, which is that we can do whatever we want all the time, and that this exception is so broad that it incorporates basically anything. They should rethink about what their ruling was on the other issues of law here. And that's why I think it's good that we had this motion for in-bank rehearing by one of the judges on the Ninth Circuit. All right, that's the Ninth Circuit status. So Posse Comitatus, that violated, absurd ruling by the Ninth Circuit. Hopefully it will be undermined in bank, and if not, by some other circuits. And the updates are that we do have some indications from the other circuits. So one update in the Chicago case, they also ruled that the deployment was unlawful. The district court in the Illinois case didn't say so for Posse Comitatus reasons, but because these preconditions weren't met, which is the initial take by Breyer. In particular, the district court found that the regular forces here is a historical reference to the military, not to civilian law enforcement. Let's see if we have that here somewhere. And then the Seventh Circuit did something interesting. Boom, where's the opinion? And I encourage you guys, go to the court listener, look at all these different cases. I put them out at the start. California, Portland, Oregon, Chicago, Illinois, Memphis, Tennessee, DC, okay? Those are the different places where they're deploying, and each one of them has a lead case. And let's see the actual TRO. Analyzing again, 10 U.S.C. 12406. This is Chicago. This is the Illinois District Court, okay? They do a bunch of historical analysis, and then they do the legal standard. Plaintiffs allege that defendants' actions, this is Trump and friends, violated statutory authority in 10 U.S.C. 12406, right? Same argument. And the 10th Amendment stuff is related to 12406. They're related. So to the extent that you're violating 12406, you're violating one of the rights and powers afforded to the states. And Posse Comitatus. Plaintiffs argue that they are likely to succeed on all their claims, so that they're entitled to a TRO. Court notes that its determination for the purpose of the TRO are necessarily preliminary ones. With those caveats in mind, court determines the TRO is warranted, first on justiciability. Defendants first challenge standing. Let's skip standing. Defendants raise 2 points in support of their argument that the president's decision to invoke 12406 is not reviewable. First, defendants cite in passing the rule that when a valid statute commits to the discretion of the president's exercise of authority is not subject to judicial review. Court takes no issue with the premise, but finds it does not apply here. 12406 permits the president to federalize whenever one of the three enumerated conditions are met, not whenever he determines one of them is met. So here, the district court is citing favorably Newsom v. Trump, but Breyer, okay? Citing Breyer, the district court. Thus, the decision to whether to federalize the National Guard, though undoubtedly a decision delegated to the president, is not one committed to his discretion alone. The political question doctrine does not apply. Secondly, defendants rely on Martin v. Mott for the specific proposition untethered to modern political question doctrine jurisprudence that the issue of whether the president properly mobilized the National Guard is not subject to judicial review. Martin invoked, again, Madison's use of the militia in 1812, same fact pattern that we just talked about. At issue in Martin was the meaning of the 1795 Act, a predecessor to 12406, which provided the following. However, the Martin case reached its decision with facts and in a context vastly different than those present here. This court reads Martin's forcefulness of speech as a reaction to those particular facts and not as conclusive on the broader issue of whether a court can ever decide whether a president has properly invoked section 12406. So the district court is saying, basically, the reason the court is using this strong language doesn't mean that they're saying that like the courts can never hear the case. They were just like forcefully responding to what Mott was trying to claim, that every militia member can decide for themselves whether something is legal. In large part, Martin was a reaction to the challenger seeking review. The Supreme Court there found it preposterous that whether an exigency existed could be considered as an open question upon which every officer to whom the orders of the president are addressed may decide for himself, and equally to be contested by every militiaman who shall refuse to obey the order of the president. To that end, the court found that the president's conclusion must be unquestionable because militiamen's prompt and unhesitating obedience is indispensable. So he's saying that discretionary question relates to the militiamen, not to the courts. Moreover, Martin also relied on the nature of the power itself, the power to call forth the militia in response to an invasion. The Supreme Court has often recognized the president's authority over foreign affairs and matters of war to be among the least appropriate for judicial review. Here, the modern version of the foreign invasion prong of Section 12406 is not at issue. The only relevant circumstances are purely domestic. Finally, in the 200 years of judicial review jurisprudence since Martin, the Supreme Court has provided ample guidance for when the political question doctrine should or should not apply. In that time, the Supreme Court has instructed the courts must make a discriminating inquiry into the precise facts and posture of the particular case. Having done so here, so he's saying political question doctrine is fact-bound. Having done so here and found the facts and posture of this case to be vastly different from those in Martin, the court is comfortable concluding that Martin's holding does not bar judicial review. So distinguishes Martin v. Mott. Now that the court has concluded that it can reach the merits of the case, it does so by beginning with 10 U.S.C. 12406, same statute we've been talking about this entire time, which states that the same thing we just looked at. When interpreting a statute that leaves key terms undefined, we interpret their ordinary meaning. Originalism, right? Several sources may be useful for determining the term's ordinary meaning, including contemporaneous decisions, dictionary definitions, other statutes, etc. Before turning to the meaning of 12406 subsections, a note on deference. Defendants are not entitled to deference on the issues of what constitutes a rebellion. These are matters of statutory interpretation. So on what the words mean, they're not entitled to deference. The court will not accept defendants' assertions that deployment satisfies 12406. So we're not just going to take your version of what these terms mean. They're entitled to a certain amount of deference on the question of whether the facts constitute the predicates. So we'll give you some deference on the analysis, but we're not going to give your deference on what the terms mean. 12406 prongs 2 and 3 broadly engage with matters of national security, and the executive is necessarily better suited than the judiciary to understand the nature of the threat. Therefore, defendants are not required to conclusively link all the pieces in the puzzle, but defendants must still support their position by pointing the court to some of the facts upon which it bases its conclusion and offering explanations which paint a substantially reasonable picture justifying the position. So it's not nearly as deferential as what the Ninth Circuit said. It's not just whether it's good faith and whether it's colorable. It's whether you can paint a substantially reasonable picture justifying your position. So they start with rebellion. I'm curious whether they go to 12406 sub 3 yet. There's no interpretation on 12406 sub 3, and this is the interesting part from this decision, separate from rebellion. The phrase unable with the regular forces to execute the laws of the United States contains several key terms. This is what we just talked about. First, unable. In the late 1800s and 1900s, unable was understood to mean not having sufficient power or ability, being incapable. So the Ninth Circuit said significant imposition. Originalist Trump appointee, I think it's a Trump appointee, or it's some conservative appointee, I forget which judge exactly. He says incapable means not capable, not having the power to do it. It's a binary. These definitions evoke a binary approach, ability or not, capability or not. This reading is consistent with the legislative history. In the words of Secretary Shaw, 12406 sub 3 was to be used when the military needs of the federal government arising from the necessity to execute the laws of the Union cannot be met with the regular forces. Great originalism there as opposed to significant imposition, right? Where does that come from? Significant imposition. What the hell is that? Are we doing the originalism or are we not? Excuse me, sorry. This is the creative aspect of the district court in Illinois. Next, the meaning of, quote, with the regular forces is one of these terms that needs to be understood, right? Key terms. Several historical sources indicate that the phrase regular forces was understood at the time of enactment to mean the soldiers and officers regularly enlisted with the Army and Navy, as opposed to the militiamen who did not make it their livelihood to serve in the country, but took arms only when called forth in times of national emergency. If you remember the discussion I had on Tim Pool, where we talked about a well-regulated militia, this is what we were talking about, right? Tim Pool said the regular forces is a reference, and I agree, by the way, to soldiers and officers, is to the regular troops, as opposed to militiamen, right? Numerous statutes refer to regular forces to distinguish the standing army from the militia. In 1806, we had the Act for Establishing Rules for the government of the armies of the United States, which referred to the regular forces. Regular forces. The regular forces referred to the troops, right? The regular troops. And this is the originalism that we're supposed to do, right? We're supposed to do this. And by that logic, right, the comparison in 124, if you take this textualist approach, this does not mean ICE is unable to execute the laws. It means the army is unable to execute the laws of the United States. That you can federalize the National Guard if you're unable to, with the army, execute the laws of the United States in a state of inability, not just significant imposition. You get me? Where are we? Shit. Yeah, we go. So here he's just going through, and this was created because they didn't actually make this argument in the Ninth Circuit. Newsom did, right? And so look at what Newsom did. Based Newsom. Can we get some W's for Newsom? So Newsom saw this argument in Chicago by this judge and sent this letter to the court, the Ninth Circuit, to the clerk for the Ninth Circuit. We want to bring the court's attention to a recent opinion in Illinois v. Trump. The district court held the reference to the regular forces refers to regular military forces. So kudos to Newsom. Kudos to the Attorney General for keeping apprised and abreast of what these other different courts are ruling and these different arguments. This is one of the reasons, really, in honesty, why it's important to have some of these issues percolate in the district courts is because people will come up with arguments and people will understand and will consider the law in ways that are critical for the Supreme Court to consider. So oftentimes the Supreme Court's willing to just willy-nilly give some shadow docket opinion based on nothing and kind of determine or at least introduce a bunch of uncertainty into the lower courts and frustrate the ability for the law to develop and to have better understanding. But kudos to California for bringing to the court's attention this argument. To date, plaintiffs in this case have assumed that regular forces refers to the civilian law enforcement personnel, but the Illinois court's construction represents a reasonable alternative both as a textual and historical matter. So kudos, you guys didn't think of it, and that's okay, right? Because this is like a term of art, and you're not necessarily going to think of it, but like I totally appreciate that the California Attorney General and Newsom, they're sending these updates to the court so that they can consider this, because they should reconsider this. This case was wrong for a bunch of reasons, and the history, the text, the law is all on the side of Illinois, of California. This is all bullshit. Later, chicken. Okay. Anyway, for a bunch of reasons, the plaintiff wins in the District of Illinois. We're going to go to the Seventh Circuit. So the Seventh Circuit, that's where the appeal was by Trump. And we have a good opinion out of that. There was an admin stay. Don't read into that. And then ultimately, there was a per curiam decision by the Seventh Circuit. On October 4th, President Trump invoked his authority under 10, again, same statute, right, to federalize and deploy National Guard within Illinois over the objection of Pritzker. He asserted that deploying the Guard in this case was necessary to quell violent assaults against federal immigration agents and property. The district court granted the request for a TRO. Because we conclude the district court's factual findings were not clearly erroneous, and the facts do not justify the action, even giving substantial deference to his assertions, we deny the administration's stay pending appeal, except we allow federalization. So this is some of these courts are making a distinction between federalization and deployment, but essentially this is a massive win for rule of law, for democracy, all that stuff. So let's actually just skip to the law real quick so you can see what the Seventh Circuit said. And this is the invocation, 12406. Before we reach the merits, we must assure that we have appellate jurisdiction. So this is the issue of like whether we can review a TRO. This is basically the hallmarks of a preliminary injunction, so we can review it. In deciding whether to stay, these are the factors. First of all, this is reviewable. Trump says it's not. He relies on Martin versus Mott. Again, recapitulation of the facts of Martin versus Mott. We do not think the holding of Martin v. Mott can extend so far as what Trump is suggesting. The court's broad language must be understood in its context. The nation was then at war with the most powerful empire on earth. That empire had actually invaded the United States, and was sacking its capital city in August 1814. The court in Martin expressed incredulity at the prospect that every officer under the president's command could make his own determination whether an imminent threat of invasion existed, and could refuse to obey the president's order or be subject to civil liability if he enforced what was later deemed an invalid order. Here, by contrast, the question is whether courts, not subordinate militiamen, may review the president's determination under 12406 primarily as to whether political protests have become violent to the extent that they constitute a rebellion, or that the administration is unable to execute federal law with the regular forces. As the Ninth Circuit aptly noted, so this is giving some kudos to the Ninth Circuit on one issue. Unlike in Dalton, the statute here enumerates predicate conditions for the president's decision to call forth the National Guard. And so here they're saying we agree with the Ninth Circuit insofar as the Ninth Circuit says this is reviewable. And so the Seventh Circuit is saying, at least on that, we agree. And I agree with that, but it's reviewable. Hence, Martin v. Mott doesn't apply. Nothing in the text of 12406 makes the president the sole judge of whether these preconditions exist. But that's what Martin v. Mott says as read by the Ninth Circuit, sole and exclusive. And here, right, the court here is basically reading Mott very narrowly. That's just the way you should read Mott, Martin v. Mott. Read it narrowly as a product of its time, related to the individual militiamen, not the courts. And the fact that it was a completely different set of circumstances relating to foreign invasion, not domestic lack of tranquility, and that it's been undermined by the passage of time and also by other case law related to the Alien Enemies Act, among other things. So unlike Martin v. Mott, which said the president is the sole and exclusive judge, the Seventh Circuit says nothing in 12406 makes the president the sole judge. Weird. At this preliminary stage, we conclude the federal government is unlikely to prevail in its argument that Martin v. Mott or Dalton forecloses all judicial review. So the Seventh Circuit, at least on the basics, which is Seventh and Ninth Circuit, both agree these are reviewable at a base level. Though we reject the administration's assertion that 12406 instills the presidents with unreviewable discretion, we agree with the Ninth Circuit that the president should be granted a great deal of deference on the question of whether one of the statutory predicates exists. As the Supreme Court has recognized, when it comes to collecting evidence and drawing factual inferences, the lack of competence on the part of the court is marked. And this, I think everyone kind of agrees. Give some deference, maybe even great deference. Even the district court in Illinois said this. The question is how much? Are you only looking for colorable and honest, or are you looking for something else? Precisely how deferential the standard is, we do not endeavor to resolve at this early stage. This is different than the Ninth Circuit, right? The Ninth Circuit did endeavor to resolve. They said it needs to be colorable and honest. Very deferential, right? Extremely deferential. Seventh Circuit says we do not endeavor. Even giving great deference to the administration determination, the district court's contrary factual findings, which at this expedited phase of the state are necessarily preliminary and tentative, are not clearly erroneous. The submitted evidence basically supports them, and no one gets deference except for the courts on what the law means. They do a little analysis of the term rebellion, which we'll save for another day, but I also want to get real quick to the regular forces. We turn next to the meaning of 12406 sub 3, unable with the regular forces to execute the laws of the United States. The administration exhorts us to accept the Ninth Circuit's reading of this subsection. The Ninth Circuit said unable means significantly impeded, and regular forces means federal officers. The district court in this case, by contrast, concluded that the definition of unable is not having sufficient power or the ability, being incapable, and it said regular forces meant soldiers and officers in the regular armed forces. We need not fully resolve these thorny and complex issues of statutory interpretation now, because we conclude that the administration has not met its burden under either standard. So what the Seventh Circuit says is, regardless of whether it's significant imposition or if it's inability, they don't win. And even if it's federal officers and not regular forces, they don't win. So regardless, you lose. This is the case that's now going to be presented at the Supreme Court. In review, great opinion by Judge Breyer. Initially, bullshit stay opinion by the Ninth Circuit seemed to be dictated by a misreading of Martin v. Mott that was dishonest, I think, in its framing, in accepting Martin v. Mott as standing for this like unquestionable deference, but the unquestionable deference seemed to say sole and exclusive, and Ninth Circuit stopped short of that, which is good, and bullshit in terms of its interpretation of 12406 sub 3, which says unable to enforce the laws, and which the Ninth Circuit interpreted as significant imposition. As Judge Breyer points out, that would create a massive hole, potentially, if it were to be read in conjunction with Posse Comitatus, for Posse Comitatus. Additionally, it's not supported by what the word incapable means, just a pure textual reading of what that means. Bullshit for a bunch of reasons, Ninth Circuit opinion. There are arguments about whether they're going to hear it in bank. That was proposed by one of the judges on the Ninth Circuit. In the meantime, Judge Breyer in the Northern District of California did a trial on Posse Comitatus, found the deployment violated Posse Comitatus after the trial. That's in proceedings right now. In Illinois, the district court in Chicago, that sits in Chicago, federal district court, found that it was violating the law under the calling forth statutes under 12406, that regular forces in 12406 sub 3 means the military people. That was a little bit of a creative new argument that wasn't present in the Ninth Circuit briefing and stuff. Newsom and company sent a letter to the Ninth Circuit saying, hey, new argument for you to peruse at your leisure. The Seventh Circuit affirmed, essentially, the finding of the district court in some respect. They didn't go all the way in affirming the different conclusions of law, but said even under the Ninth Circuit standards, government loses. Similar set of circumstances in the District of Oregon, which will appeal up to the Ninth Circuit as well. Just a heads up. I'm not going to review it right now, but the current state of play in Oregon is the deployment is also stopped in Oregon as illegal. We just today had the announcement of a filing of Shelby County in state court, right, in the Chancery Court for the state of Tennessee. We'll see how that goes. This is internal local officials suing the state officials, right? The mayor suing the governor. And in DC, you have a separate set of arguments that we'll get into at some point related to the Home Rule Act of DC. Because remember, this is typically already federalized under the president's authority, the DC National Guard. And I don't believe there's been action on this deployment yet. So the three deployments of the big three states, Oregon, California, and Illinois, have been found illegal in some respect. Some little legal nuances there. One bad opinion out of the Ninth Circuit, but ultimately preserving judicial review, which is good. Hopefully it will be curtailed significantly in light of its myriad deficiencies. And the Seventh Circuit and District Court in Illinois being based as fuck. That's the review of the various different cases. Let me know if you have any questions. Let me know if that was helpful. I don't know if that was helpful. Sometimes it's useful for me to like take a step back and be like, these are all the cases about the military stuff, because you can lose sight of like everything that's occurring.